Hi! In this video, we are going to discuss the case of Josefina S. Lubrica et al. Versus Land Bank of the Philippines, GR number 170220, promulgated on November 20, 2006, penned by Justice Inare Santiago. The facts of the case are the following. Petitioners Lubrica and Suntay et al. Are assignees and heirs respectively of Federico C. Suntay over different parcels of agricultural land in Occidental Mindoro. In 1972, due to the enactment of Presidential Decree No. 27, a portion of these properties were subdivided and distributed to farmer beneficiaries. The Department of Agrarian Reform or DART and the Respondent Land Bank of the Philippines or LBP fixed the value of the properties, but this was rejected by the petitioners. For this reason, the Office of the Provincial Agrarian Reform Adjudicator or PARAT conducted summary administrative proceedings for the determination of just compensation, which was then questioned by the respondent. The petitioners filed separate motions, praying, among others, that LBP deposit the preliminary compensation determined by the PARAT. The trial court granted the petitioner's motion, and LBP was ordered to make the deposit within 5 days from the receipt of a copy of the order. LBP filed a motion for reconsideration, but it was denied. Thus, they filed a motion for certiorari and prohibition before the Court of Appeals, with application for the issuance of a temporary restraining order and a writ of preliminary injunction. On May 26, 2004, the CA rendered a decision in favor of the petitioners and held that the trial court correctly ordered LBP to deposit the amounts provisionally determined by the PARAT, as there is no law which prohibits LBP to make a deposit pending the fixing of the final amount of just compensation. It also noted that there is no reason for LBP to further delay the deposit, considering that the DAR already took possession of the properties and distributed the same to farmer beneficiaries as early as 1972. However, the motion for reconsideration filed by LBP was granted by the same court. The CA reasoned that the immediate deposit for the preliminary value of the expropriated properties is improper because it was erroneously computed. It held that the value of the government support price for the corresponding agricultural produce should be computed at the time of the legal taking of the subject agricultural land, that is, on October 21, 1972, when landowners were effectively deprived of ownership over their properties. The petitioners argue that the determination of just compensation should be based on the value of the expropriated properties at the time of payment, whereas the respondent avers that the value should be computed as of October 21, 1972, when Presidential Decree 27 took effect. The issue now is whether or not the determination of just compensation of the expropriated properties should be based on the value at the time of payment. The Supreme Court held that yes, the compensation should be based on the value of the property at the time of payment, not when PD 27 took effect. They reasoned that as early as 1972, the petitioners were deprived of their properties and their use when the parcels of land have been subdivided and distributed to the farmer beneficiaries without receiving the just compensation therefore. Hence, it is only equitable for them to receive such compensation computed using the values at the time of payment and not at the time of taking. The Supreme Court noted that the expropriation proceedings in this case was initiated under PD 27, but the agrarian reform process is still incomplete since the just compensation has yet to be settled. Therefore, considering the passage of the Comprehensive Agrarian Reform Law or CARL, or RA 6657 before the completion process, The just compensation should be determined and the process should be completed under the said law. PD 27 and Executive Order No. 228, Series of 1987 will only have suppletory effect. Citing a long line of cases, the court explained that the CARL conditions the transfer of possession and ownership of the land to the government on receipt by the landowner of the corresponding payment or the deposit by the DAR of the compensation in cash or LPT bonds. Otherwise, the title will remain with the owner. In the case of the petitioners, they have been deprived of their properties for decades without receiving just compensation. Although the title remained with them, still, the government and the farmer beneficiaries already benefited from it. Thus, it would certainly be inequitable to determine just compensation based on the guideline provided by PD 27 and EO No. 228, considering the failure to determine just compensation for a considerable length of time. The compensation should therefore be based on the value of the property at the time of payment and not when PD 27 took effect. So ordered. Thank you.